Hi, everybody. I'm Beth Rebay, the host of the Civics Project and the Director of Repair, which sponsors the Civics Project. Welcome to our 37th recording. The theme today for the Civics Project episode is the Violence Against Women Act. Before we begin, I'd like to start with a brief land acknowledgement. Repair acknowledges the Gabrielina Tongva peoples as the traditional land caretakers of Tobangar, the Los Angeles Basin and South Channel Islands. And we are grateful to have the opportunity to work for the Turahato, the indigenous peoples in this place. We pay our respects to Hanukvatam, the ancestors, Ahihiram, the elders, and Iohinkem, our relatives and relations, past, present, and emerging. As noted, our theme today is the Violence Against Women Act of 1994, also known as VAWA or the VAWA. The Violence Against Women Act was embedded initially in 1994 in a larger piece of legislation known as the Violent Crime Control and Law Enforcement Act of 1994. And it was then expanded and improved in 2000 and 2005, so it's been amended over time. The Violence Against Women Act, because it requires funding from Congress, also has to be reauthorized, basically given a new budget allocation for each year. So it's legislation that's sort of always evolving in that way. So I want to talk a little bit about the history of the passage of the Violence Against Women Act, without delving into sort of a much deeper conversation about the history of gender violence in the United States. We have to note that, early statutes which in US states and municipalities which regulated or placed criminal restrictions on gender violence evolved significantly over time. So there were plenty of periods in the 18th and 19th century and in the colonial period in which gender violence against someone who you essentially had legal guardianship or custody over, whether that was a wife or a child, was not something that laws tended to intervene in unless the incidents were extreme enough to perhaps maim or to cause death. And even then, the penalties were often attenuated or reduced if you were engaging in gender violence in an intimate partner setting as compared to against a stranger. Our criminal law has a history of crime of passion defenses, so, which basically indicated that you could mitigate your guilt if you killed your wife as opposed to killed a woman that you didn't know based on sort of the passions presumably involved in marriage. There were also some forms of gender violence which simply weren't recognized in particular time periods and states. For instance, we didn't really start to see legal systems recognize sexual assault if it was against a partner, meaning a wife, until basically the 1980s, when you first started to see the initial statutes emerge at the state level. So here we are, it's the 1990s, the second wave of feminism happened a generation ago and created a groundswell of localized and grassroots energy, some of which was also well networked at the national level among people who wanted to address the ways in which violence were part of the systemic experiences that girls and women were enduring and had been for generations in US society. And all of this eventually coalesced into a lobby. And some of that came from the National Organization for Women Legal Defense and Educational Fund. They basically teamed up with then Delaware Senator Joe Biden, who now obviously we know as both Barack Obama's vice president and as our current US president. So Biden, in concert with the National Organization for Women and the staff of the Senate Judiciary Committee, formed a coalition which then over time became known as the National Task Force to End Sexual and Domestic Violence. And that task force continues to exist today and to work on each reauthorization of the Violence Against Women Act in Congress. The emphasis became on the term violence against women, and I want to note that that's a limitation just because many of the kinds of violence contemplated in the act actually also affect girls, particularly teen girls, if we're talking about dating violence and sexual assault. So the Violence Against Women Act is mostly framed in adult terms, though over time, some of the funding available through VAWA also does reach teenagers. The act was hard to pass, although by the time that it did pass, it had acquired substantial support. So at the time of its passage, 68 senators were actually sponsoring or co-sponsoring the bill. And in the House, there were 226 co-sponsors, and that reflected bipartisan support. So by the time it finally passed after 4 years, there was no question that it was going to pass. It already had the votes just from its senators. To have 68 sponsors is a pretty significant number. That means you've already got a supermajority even before you go to a vote. The initial bill contained, it's dense and would take a long time to read, but it contained a number of different provisions. Some of it was focused on the prevention of violence. Other elements of it started funding at the federal level victim services. Others focused on the evidentiary standard on ways to improve the law enforcement response and recognition of domestic violence and sexual assault. And it also created the first federal criminal law against battering. And it had what's called a full faith and credit provision for protection orders. So for those who don't remember what full faith and credit means, it's a legal concept which basically indicates that something which is created within one state will be recognized by others. So for instance, if you get married in Nevada, even though Nevada's marriage laws are less restrictive than other states, you can take your marriage license and certificate from Nevada and have your marriage recognized in New York or Texas or South Dakota, right? So that concept, which allows states to recognize, basically actions performed under other state laws, is what's called full faith and credit. So the Violence Against Women Act said the same principle should apply to orders of protection. If you get a criminal court to issue a restraining order against a perpetrator of gender violence, and then the person who got the restraining order moves to another state, the other state will also recognize that order of protection under the Violence Against Women Act. It also contained one of its most initially and still controversial portions of what's called a civil rights remedy. And this particular provision allowed victims of gender violence to sue their attackers for violating their civil rights based on their gender. The remedy was modeled after late 19th century laws that had been intended to protect African Americans. So to help you understand what that means, most of the time, civil rights laws in the United States, such as the Civil Rights Act of 1964 or the Americans with Disabilities Act, basically create categories in which discrimination cannot occur. So they say the government cannot discriminate, including states and municipalities. Private businesses cannot discriminate, but those laws don't prevent somebody from, let's say, screaming a racial slur at you in the street as a private person. What they do is restrict, basically businesses and public entities. And sometimes they do things like protect voting rights. So to find an example of how someone could just sue an individual for violating their civil rights, even though they weren't doing it in the name of a federal or state or municipal government, the Congress went to the 19th century models of the 19th century Congress after the Civil War, passing the Ku Klux Klan Acts and other kinds of laws which allowed people to sue a perpetrator who was acting as if they were behaving like the state, like the KKK, or like people vandalizing places of worship, basically trying to terrorize people based on their race or their religion. And it said, you know, this gives us an example of where the federal government has allowed people to sue somebody who's trying to take away their rights based on their membership in a category, even if they are not a business or acting on behalf of the government. So they tried to do something similar in Violence Against Women Act. And again, this was expansive beyond what our 1960s era civil rights law did. And they justified it in a number of ways, which we'll get to in a little bit. But I want to say why this, part of why this was so controversial and what drove the major delay for 4 years in passing the Violence Against Women Act was an initiative spearheaded by Supreme Court Chief Justice William Rehnquist. So in partnership with multiple judicial organizations, meaning national organizations for the most part, I think some state ones as well, for judges, Rehnquist led opposition to the civil rights remedy in the Violence Against Women Act. And the opposition was grounded in the notion that if victims of gender violence could sue their attackers, the federal courts would just be flooded with cases of domestic violence and sexual assault. And the argument Rehnquist was making here is these are family disputes. They don't belong in the federal courts. And we will be overwhelmed if everybody who, you know, is abused by a partner can go to federal court. So the judges really lobbied hard, and the only exception to this in terms of basically national organizations for judges was the National Association of Women Judges, NAWJ. So the National Association of Women Judges basically then teamed up with the Senate Judiciary Committee and the National Organization for Women, and they worked on redrafting the bill to get past the opposition of Rehnquist and other judges. And, you know, basically the process of passing the bill, though it was delayed for 4 years, eventually reached a point in which every objection had been addressed. They had overwhelming support in Congress, including at least some Republican support. And at that point, the bill was able to be passed and then signed into law by President Bill Clinton. After its enactment, and the civil rights portion of the Violence Against Women Act was upheld as it was challenged multiple times in the federal courts. So these challenges kept saying, this is not constitutional, you can't sue a private person, Congress doesn't have the authority to do this. If you can't sue a private person as a civil rights issue, Congress doesn't have this authority, this should not be upheld. And it was challenged, and it kept being upheld in the lower courts. Finally, however, in 2000, the civil rights portion of the Violence Against Women Act made it up to the Supreme Court. And you guessed it, Chief Justice William Rehnquist wrote the majority of opinion, and in a 5-4 decision, they struck down the provision and said it was unconstitutional and could not continue to operate. And so the Violence Against Women Act lost its civil rights protection for gender violence victims. Now, I want to explain more about what the legal arguments were and more about what this means. Why does it matter? Why would it be important to have a civil rights remedy? So the legal questions that the courts had to hear were on two bases. One is about the Commerce Clause, and the other is about the 14th Amendment. So the Commerce Clause, which we've not really talked much about before in the Civics Project, is a provision in the Constitution which says that one of the powers of the US Congress is to pass legislation to regulate activities that affect commerce between the states. So basically, the Commerce Clause has been interpreted to say if it's economic, if it has a significant economic impact and it's not only affecting a single state, then Congress is allowed to legislate about it. And it's good to remember, Congress doesn't have the authority to pass legislation about any and everything. Our Constitution gives some power to the state, some power to the federal government. So one of the ways in which Congress gets to intervene in things that affect the state level is if there's an argument that it affects the interstate economy. And over time, the Commerce Clause of the Constitution has been interpreted broadly in the courts in order to enable Congress to pass some kinds of legislation at the federal level, which otherwise might be regulated by the state. So Congress, in drafting the civil rights remedy in the Violence Against Women Act, which allowed victims of violence to sue their attackers, even if they were private people and not be acting on behalf of the government or a business in any way at the time. Congress made this argument saying, you know what, we are spending just on domestic violence $5 to $10 billion a year in taxpayer money on criminal justice, on healthcare, and on other forms of spending that deal with this activity. This is actually affecting interstate economies significantly. And so that was Congress's argument for why they had the authority to pass this piece of the legislation. You know, other parts of the Violence Against Women Act were less controversial because they were about either federal criminal law, which Congress has jurisdiction over, or about Congress giving out grants and resources and technical assistance to states, municipalities, and local organizations, which it's also allowed to do and can do in many different settings. But the question of allowing, you know, creating this civil rights remedy, which people could bring to the federal courts, they had to justify, and they in part use the Commerce Clause to do it. The other basis that had been argued to defend the civil rights portion of the Violence Against Women Act was the 14th Amendment. And the 14th Amendment, as we know, has the Due Process Clause, which basically, you know, says the states can't take away the rights that have been recognized as belonging to individuals, and, you know, which rights are in question varies. And also contains the Equal Protection Clause. And I have to say, this was a tricky argument for Congress to make, because the language of the 14th Amendment basically says that states, you know, can't deny people equal protection of the laws or violate their due process rights. And there's not really an argument that a private person can violate your 14th Amendment rights unless they are acting on behalf of the government, essentially. And so this was a bit thinner, but I think Congress wanted to at least make a strong argument that it was a question of equality, and did make some arguments to say, or at least, you know, some of the advocates for VAWA did make the argument that we should understand gender violence as in many ways structured and enabled by the state, because we have systemic gender inequality in our economy and politics and history, and all of that makes it easier for gender violence to occur at the local level because women and girls have less power socially. So it was a more roundabout argument to try to bring in the 14th Amendment. And the court basically said and interpreted the Commerce Clause more strictly. So prior precedents had allowed Congress a fair bit of latitude to say, well, if it has an economic impact, then Congress can legislate about it. And the court here, basically restricted the interpretation of the Commerce Clause and said, domestic violence isn't an economic activity, so Congress really shouldn't be legislating about this. And it wasn't clear what the court was thinking about the arguments that actually domestic violence has a major economic impact, which had been persuasive in prior cases. But regardless, they went ahead and indicated that there was no constitutional basis for Congress to legislate in this way, and they struck it down as noted with 5-4 majority. So after this, and since then, there has been no basis under civil rights law for a victim, for instance, of rape or intimate partner violence or stalking to sue in federal court their attacker, unless the attacker happened to somehow be representing the government at the time. This might come into play, for instance, if you were incarcerated in a federal prison and there was a prison guard who sexually assaulted you, right? Then it might be, then you could make a constitutional argument conceivably because you are under the authority of the state. And there's also, a body of prison law that bears on this question. But for ordinary victims of gender and domestic violence, of stalking, this meant the option to sue your perpetrator under federal civil rights law was taken away. And again, this was the US versus Morrison decision in 2000. So there's some important questions that people tend to raise about this decision, US versus Morrison. One is, does this mean that victims of violence can't sue their attackers? No, it doesn't mean that. There's still other areas of state and municipal law that would allow somebody to file a lawsuit against someone who sexually assaults or abuses you. You could do so for assault under what's known as torts law for our non-lawyers. Torts, again, is a sort of broad area of law, of civil law, in which people can sue others for wrongs done, including violence. So torts law includes anything from a slip and fall to a driving accident or car accident, but it can also include what are known as intentional torts when one person attacks another. So you could still sue for damages, sue for harm under municipal or state law, usually state law, using tort statutes, and individual states can also create particular protections for victims of violence that might allow them to sue. So it doesn't mean that victims of violence can never sue their perpetrators. We know that they do. We hear about those cases. What it does mean is that there are not a lot of ways that someone could ever bring a claim like that in federal court. And one of the things that means is that if your state doesn't have a lot of options for victims to take action against their perpetrators, then you would kind of be out of luck. So if your state law is not working for you, if the only place you can go is state court, and there's no federal law, then the options to sort of take action become more limited. And it also means that the sort of burden of proof and evidentiary standards and damages available can vary really widely between, from state to state and sometimes locality to locality. It means there's no one federal standard of what someone can ask for and what they would have to prove to sue a batterer, a rapist, a stalker. So we can think about, why does that matter, right? And we partly answered this question already, right? If you don't have a state which has good laws on this issue, then you would be essentially out of luck. Having the option to go to federal court also recognized gender violence as a political equality issue. So rather than an individual harm person to person, it looked at it as at a systemic level. It said, if we have these epic rates of gender violence where we can document conservatively that 1 in 3 adult women will have experienced battery during her lifetime, and our rape statistics are alarming on a domestic scale and put us at the extreme end of basically rape-prone societies, or societies which are, as anthropologists call them, rape cultures on a global scale. Not that we're unique on this case, but that we're at the worst end of the spectrum. So, certainly anti-violence advocates and feminists have argued for a long time that we need to understand gender violence as a political and structural issue. So recognizing it as a civil rights issue was a step in that direction, and the US versus Morrison decision sort of re-relegated gender violence to a private issue, a family issue, not one that should be understood as political. So just as a sort of, major question in how the public views gender violence, taking away the question of civil rights also had a sort of impact in public understanding. We can also note a few other things that I think were lost in the US versus Morrison decision. The court, by saying that domestic violence was economic, also ignored some of the economic dimensions of domestic violence. While domestic violence certainly doesn't always have to be economically motivated, we know that there's at least a subset of domestic violence cases which also involve financial abuse or exploitation of the people being abused. In addition, domestic violence is very much associated with lost productivity for people who are being abused and are losing their ability to show up to work regularly, to hold down a job. So domestic violence actually has a significant impact on worker productivity in the United States, as does sexual assault. So, one of the things that the US Morrison decision has raised for us since is, how do we draw a line between economics and families when they are so interconnected, between work and health when they are so interconnected? Another critique that's been raised of the U.S. Morrison decision and of our whole model of thinking about gender violence in the United States is the critique that we should not just think about the state acting based on what people who are in state jobs and government jobs do, but rather we should think about state action as including the failure to protect citizens, right? So the state has enormous control over economics, over human rights and civil rights, over which powers are given to particular entities. The state does a lot, the government does a lot to structure our lives. And, one argument is also that if the structure of our society is such that it's continually allowing people to abuse others, that we should see the state as acting by having sort of set the stage for violence. So this is what I would think of as a sociological critique, that society sets the stage for gender violence to be possible, structures the law enforcement response, empowers perpetrators in the different ways that over time it has enabled abuse. And therefore we should view everything, that we should view everything that the state doesn't do to intervene in gender violence as state action, basically failure to protect. So some dense social and theoretical issues are obviously bound up in this piece of legislation, but I want to say a little bit about how it's affecting our lives today and about the problems that it was intended to address. In 2021, just under $500 million in funding has been allocated through the Office for Violence Against Women, some of which funds its own activities and a fair bit of which allocates out through community and state level grants, many of which channel into individual organizations such as domestic violence and rape crisis organizations. And that's, adjusting for inflation over time, that's pretty typical. So one of the major impacts of the Violence Against Women Act as of its implementation since 1994 has just been that it's become a source of funding to allow local organizations to do their work with victims of violence and at least to do some prevention work. There are also certain ways that it does either provide resources or guidance to criminal justice systems. And as a consequence, if you asked advocates, is the Violence Against Women Act important even after United States versus Morrison, people would say absolutely. If you took it away, for instance, we would see an immediate community level impact for organizations that are trying to address sexual assault, domestic and intimate partner violence, and stalking. And the mandate of VAWA over time has sort of expanded to encompass various kinds of entangled abuse, such as violence against elders, violence against people with disabilities. And sometimes, though the emphasis is on gender violence, it can absolutely benefit victims who are female, male, or gender non-conforming because it addresses and funds resources, that are not gender discriminatory in their service provision. So one thing we can think about, though, is that the proposed intention and mandate of the Violence Against Women Act was to end sexual assault and domestic violence. And it's been around for 27 years, 26 since it was implemented, which is not that long, but is still a full generation. And one of the things that we know is that the rates of incidence of gender violence have not significantly decreased sometimes in some municipalities, but not in a way that we can certainly associate at a federal level with the existence of the Violence Against Women Act. So I think that while folks would simultaneously say we shouldn't repeal it, most advocates today would agree that it's, inadequate. It's not accomplishing what it was purported to achieve or intended to achieve. So, a question we can ask is the Violence Against Women Act failing? And what we can say is, yes, it's failing to end sexual and domestic violence, but it is, if it were strengthened, and if it were coupled with many other civic and localized actions and steps, it might not be failing. So on its own, it's failing, it's inadequate. But if it were shifted, if it were strengthened, if, for instance, the civil rights remedy were restored, if the budget was adequate to meet the needs of victim services, if it created more comprehensive ways to address the roots of gender violence rather than so much emphasis on the criminal justice response, which we know is dysfunctioning in a whole set of ways in the United States, it could conceivably become more successful. So, we can also think about what else exists as a constitutional foundation for expanding the Violence Against Women Act. And I would close with the thought that one of the things that we might do in order to strengthen our federal protections for anti-violence legislation would be to pass the Equal Rights Amendment. So the Equal Rights Amendment, basically recognized sex discrimination as something which should be understood as significant in the Bill of Rights, and would have created a very solid ground for courts to say, if something is causing gender discrimination, sex discrimination, then there's a constitutional basis for the government to act to stop it. So whether it's the Violence Against Women Act or other steps that Congress might take, but would fear could be struck down as US versus Morrison would, one of the ways to address this question is to amend the Constitution. Now, granted, that's never an easy thing to do, but there has been revived interest in essentially resurrecting the Equal Rights Amendment, which never passed all of the states that it would have needed to in order to amend the Constitution. So that's one possibility. And we can also talk about deeper remedies at the localized level. And for our Zoom audience, I'm glad to discuss that more if you would like. My reading recommendation for today is a book that came out, a collection that came out around the time of the Violence Against Women Act in the mid-90s. The title is The Violence Against Women, The Bloody Footprints. The editors are Pauline Bart and Eileen Gill Moran. And again, that's Violence Against Women, The Bloody Footprints. And it was an edited collection of research by sociologists who were looking at all of the social and structural dimensions of gender violence. So in thinking about how could policy deepen its response to the problem, I think that's a useful book to take a look at. And again, it deals with both individual acts of violence, but also with the systemic response, including, for instance, through policing. So again, an older text, but one that I think is still appropriate and relevant to think about from a policy standpoint. And that again is Violence Against Women, The Bloody Footprints by Pauline Bart and Eileen Gill Moran. I want to invite folks to join us next week. Our episode last weekend was postponed because I had a cold and lost my voice. But we'll be back next Sunday to talk about the minimum wage. So look forward to seeing more of you then. And thanks so much for everybody for listening in, for joining us in Zoom. And we will be back soon.